The Insular Cases are a series of opinions by the U.S. Supreme Court in 1901 about the status of U.S. territories acquired in the Spanish-American War. The Supreme Court held that full constitutional rights do not automatically extend to all places under American control. This meant that inhabitants of unincorporated territories such as Puerto Rico, even if they're U.S. citizens, may lack some constitutional rights. The court also established the doctrine of territorial incorporation, under which the Constitution applied fully only in incorporated territories such as Alaska and Hawaii, whereas it applied only partially in the newly unincorporated Puerto Rico, Guam and the Philippines. The term insular signifies that the territories were islands administered by the War Department's Bureau of Insular Affairs. Background: in 1898, the United States signed the Treaty of Paris, which ended the Spanish-American War and granted the United States the Philippines, Puerto Rico, and Guam. Additionally, Cuba remained under the jurisdiction of the United States military government until its independence on May 20, 1902. At the time, there was a debate on how to govern these new territories since nothing was said about it in the U.S. Constitution. The cases were the court's response to a major issue of the 1900 presidential election and the American anti-imperialist league, summarized by the phrase, "Does the Constitution follow the flag?" List of the Insular Cases. Various authorities have listed what they consider are the legitimate constituents of the Insular Cases. Juan Artaruella, a judge on the U.S. Court of Appeals for the First Circuit, considers that the landmark decisions consisted of 6 fundamental cases only, all decided in 1901. Strictly speaking, the Insular Cases are the original 6 opinions issued concerning acquired territories as a result of the 1898 Treaty of Paris. These 6 cases were: De Lima v. Bidwell, 182 U.S. 1. Gertzi v. United States, 182 U.S. 221. Dooley v. United States, 182 U.S. 222. Armstrong v. United States, 182 U.S. 243. Downs v. Bidwell, 182 U.S. 244. Lewis v. New York and Puerto Rico Steamship Co., 182 U.S. 392. Other authorities, such as José Trias Monge, a former Chief Justice of the Puerto Rico Supreme Court, states that the list also includes these additional 2 cases also decided in 1901. Dooley v. United States, 183 U.S. 151. 14 Diamond Rings v. United States, 183 U.S. 176. Law professor Pedro A. Malave wrote in his book America's Colony, The Political and Cultural Conflict Between the United States and Puerto Rico, that while many law experts include cases from 1903 to 1979, some scholars limit the number of cases in the list to just 9, adding Crossman v. United States, 182 U.S. 221. 6 of the 9 Insular cases only involve Puerto Rico. Constitutional law professor Efraín Rivera Ramos argues that the Insular Cases designation has been extended beyond the first 9 cases in 1901 to include additional cases decided between 1903 and 1914. Hawaii v. Mankichi, 190 U.S. 197. Gonzalez v. Williams, 192 U.S. 1. Kepner v. United States, 195 U.S. 100. Dorr v. United States, 195 U.S. 138. Mendoza v. United States 195 U.S. 158. Rasmussen v. United States 197 U.S. 516. Trono v. United States 199 U.S. 521. Grafton v. United States 206 U.S. 333. Kent v. Puerto Rico 207 U.S. 113. Copel v. Bingham 211 U.S. 468. Dowdell v. United States 221 U.S. 325. Ochoa v. Hernandez 230 U.S. 139. Ocampo v. United States 234 U.S. 91. The insular cases hence often include De Lima v. Bidwell 182 U.S. 1, argued January 8–11, 1901, decided May 27, 1901. Gertzi v. United States 182 U.S. 221, argued December 17–20, 1900. January 14–15, 1901. Decided May 27, 1901. Armstrong v. United States 182 U.S. 243, argued January 8–11, 1901. Decided May 27, 1901. Downs v. Bidwell 182 U.S. 244, argued January 8–11, 1901. Decided May 27, 1901. Lewis v. New York and AMP Puerto Rico SS. Co. 182 U.S. 392, argued January 11–14, 1901. Decided May 27, 1901. Dooley v. United States 183 U.S. 151, argued January 8–11, 1901. Decided December 2, 1901. 14 Diamond Rings v. United States 183 U.S. 176, argued December 17–20, 1900. Decided December 2, 1901. Hawaii v. Mankichi 190 U.S. 197. Kepner v. United States 195 U.S. 100. Dorr v. United States 195 U.S. 138. Gonzalez v. Williams 192 U.S. 1. Rasmussen v. United States 197 U.S. 516. Dowdell v. United States 221 U.S. 325. Ocampo v. United States 234 U.S. 91. Balzac v. Puerto Rico 258 U.S. 298. Torres v. Puerto Rico 442 U.S. 465. Criticism. Former Puerto Rico Supreme Court Chief Justice José Trias Monge contends that the insular cases were based on premises that would be considered bizarre today, such as democracy and colonialism are fully compatible. There is nothing wrong when a democracy such as the United States engages in the business of governing other subjects that have not participated in the democratic election process. People are not created equal, some races being superior to others. It is the burden of the superior peoples, the white man's burden, to bring up others in their image, except to the extent that the nation which possesses them should in due time determine. In Harris v. Rosario 446 U.S. 651, the court applied Califano v. Torres, 435 U.S. 1 in of succinct per curiam order, holding that less aid to Puerto Rican families with dependent children did not violate the Equal Protection Clause, because in U.S. territories Congress can discriminate against its citizens applying a rational basis review. Justice Marshall wrote a staunch dissent, noting that Puerto Ricans are U.S. citizens and that the insular cases are questionable. In Torres v. Puerto Rico, 442 U.S. 465, cited above, Justice Brennan, with whom Justice Stewart, Justice Marshall, and Justice Blackmun joined, concurring in the judgment, cited Reed v. Covett, 354 U.S. 114, in which Justice Black said the concept that the Bill of Rights and other constitutional protections against arbitrary government are inoperative when they become inconvenient or when expediency dictates otherwise is a very dangerous doctrine, and if allowed to flourish would destroy the benefit of a written constitution and undermine the basis of our government.